Good morning, my lordships, my ladyships. My name is Yannick Zave, ID number 202-70701, and I appear on behalf of the respondent, Ms. May. Today, my submission will be 10 minutes, and I will be making my submissions based on 2 points. The points will be as follows. Firstly, the exclusion clause was not incorporated into the contract because reasonable steps had not been taken to bring it to the attention of the claimant. Secondly, in any event, when applying the test for reasonableness based on the Unfair Contract Terms Act 1977, the clause would have been invalid. Would the lordships care for a brief summary of the facts? Thank you. The facts are as follows. My client, Ms. May, went to the appellant's place of business to have her silk-lined gown and other garments cleaned. Upon her return to collect said gown, she was told by a company representative that the gown had been destroyed due to their negligence. Thus, them seeking to rely on a clause where they had a sign hung in the back of the shop, obstructed from the view of my client, stating that they will not be liable for any negligence. Would the lordships allow me to please make my first submission? Thank you. Submission number 1. That clause that hung behind the counter, invisible, cannot be held valid based on the following point of law. I submit to you Parker and Southeast Railway 1877, number 2, Criminal Pleas Division, page 4416, excuse me. In this case, Parker, traveling in the station, lost his bag in the courtroom. Relying on a clause which existed on the backside of his printed ticket, which stated the company, the railway company that is, will not be liable for damage exceeding £10. No, Mr. Parker's bag exceeded £10 in value. In this situation, my lordships, it was found that the test was whether reasonable steps were taken to bring the clause to the attention or not. And it had no relevance if you read that notice. Thus, to compare it in our scenario, reading the sign alone, partially as she did, could not apply to be noticed. I will now dispense with formal citations if it would please the court. Turning me to submission number 2. This case is called Interphoto Picture Library and Stiletto Visual Programs Limited, 1989. So it's found in the Queen's Bench Division. In this case, the defendant ordered transparencies from the claimant. The claimant sent the transparencies along with a delivery note stating that any period past 14 days that the claimant kept the photos, they'll be charged £5 per day and will be paid every day past the 14 days. So this means in that scenario, what happened is that the claimant actually kept the photos an entire month. What the court found in this instance was that sufficient notice was not given. And the authority coming out of this was the party seeking to rely on the clause when there is an onerous term, as it so happened, must draw it to the attention of the other party. A quote coming out of this case by Lord Bingham LJ stated that the question was at hand was whether in all circumstances, be it fair and reasonable, to hold a party bound by any conditions unusual and stringent in nature. I might draw an amalgam to our situation here today, my lordships. Surely, a fair-paying customer expect to have no liability or negligence in the form of business which they are operating must be unreasonable and must be stringent and require extra attention to be drawn. My lordships, I turn to submission point number 3. This case is called AEG UK Limited and Logic Resource Limited. The defendant received an order for goods of equipment from a client in Iran. He sent a purchase order to the claimant. The claimant sent back a document with confirmation. On this said document, there were terms and conditions listed in the back that required that defective goods be sent back by the cost of the claimant, of the defendant, excuse me. The Court of Appeal in this matter held that unusual and onerous terms requirable reasonable notice of incorporation. Hurst LJ said that when a condition is onerous and unusual, to determine whether the condition has been incorporated into the contract, the correct test was whether the contract was fair and reasonable, being brought to the attention of the defendant. I know the court hears a trend happening. Framing this in the light of our scenario, we can clearly see that extra steps must be taken, not merely casual notice. My final submission, my lordships. Thornton and Shoe Lane Parking Limited, 1971. Mr. Thornton, driving his car into a car park, approached an automatic ticket machine to which he paid his money and received his ticket. Upon entering the car park, what happened is that he saw a sign negating negligence by the company owning the car park, stating that they will not be held for liable for accidents which occur on the compound. Now here we have a scenario where money was paid before entering and viewing the sign. So the transaction had already been done. It was held that that clause was not successfully incorporated and there had not been enough information prior to incorporate the terms into the contract. And what was realized was that the exclusion clause must be presented before the transaction occurred. So my client was supposed to know of the situation before coming to that shop counter and reading that sign, even if she did read the sign. My lordship, I will turn to my second submission. This will be the submission by the Contract Terms Act 1977, where it has been determined that there is a need for clauses in relation of excluding liability in relation to negligence should be covered by this act, negligence being covered by section 2.2 of that act. This will be dealing with 2 points. One is where there's death or personal injury, which is not our scenario, but secondly, where there's a satisfaction of a test for reasonableness as defined by the act. The test for reasonableness can be found in section 11.1. It provides that in relation to a contract term, the requirement of reasonableness should exist. This term means that fair and reasonable, one to be including the circumstances which were ought to have reasonably known in the contemplation when the contract was first made. A successful claim under section 2 can be found in Philip Products Limited and Highland Hampstead Plant Hire Co. Limited, 1987. In this matter, the claimants hired a driver as well as rented an excavator from the defendants. Under the contract, it was stated that the driver should be an employee as to be considered by the claimants. Right? That means that any negligent liability arising out of the actions of the driver should be the responsibility of the claimants and not the defendants. That is what they purported by this clause. Lord Slade LJ said no and rejected the claim, stating that section 3.1 encompasses terms and notice which receive and try to exclude liability for a relevant obligation or duty. There can be no doubt that the duty of a dry cleaning company is the restoration of their client's clothes, not the destruction of it. I would like to invite your lordships and ladyships to dismiss the appeal, uphold the decision of the trial judge, and find that the exclusion clause was not incorporated into the contract because reasonable steps had not been taken to bring it to the attention of my client, and any doubt is had. The test for unreasonableness by Octa 1977 has not been fulfilled. Thank you.